Welcome to Learn About Law. My name is Kevin O'Flaherty from O'Flaherty Law, and today we're going to talk about one of the 8 goals of a good estate plan, and the goal we're going to talk about today is distribution of assets. So this podcast and video blog is the third in a series of many that are going to discuss the 8 goals of a good estate plan. If you want to learn about any of these goals in more detail, you can go to learn-about-law.com, where you can read our article on the 8 goals of a good estate plan and each of the separate articles dealing with each of those goals. So please feel free to check that out for some frame of reference. But today we're going to talk about distribution of assets. So this is something that we can accomplish with either a will or a trust. You can decide how your assets are going to be distributed. If you don't have a will or a trust when you pass away, state statute is going to determine how your assets will be distributed. The state statute in Illinois says that if you're married, your spouse is the first to inherit, followed by your children, followed by grandchildren or other living descendants. And then if you don't have any descendants, it'll go to your parents if they're living, then to siblings, and then to nieces and nephews. And then it gets a little bit more complicated. So for people who want that to happen, who just want everything to go to their spouse and then in equal shares to their children, there's not a lot from a distribution point of view that you can accomplish with a will or a trust. Now, there's some caveats to that, because a trust will allow you to have control on how quickly those assets get paid out. So if you've got kids that are minors, 15, 8 years old, you don't necessarily want all those assets to get dumped on their legal guardian when you pass away. So even if you want things to go in equal shares to your children, a trust might make sense. Or if they're young adults, you don't necessarily want the young adult child to get access to their entire inheritance at 23 when they're not old enough to be responsible with it. So you have to factor in when those amounts are going to get paid out and how they're going to be managed as one of your distribution goals. But if you've got adult children, in their 30s, and all you want is for everything to go to your spouse and then divide it equally among your adult children, then there's not much that a will or a trust can accomplish from, again, a distribution point of view. They can both accomplish a lot of other things, and we deal with that in our other podcasts and video blogs about the other goals of a good estate plan. So when does it make sense to use a will or a trust to actually handle the distribution of your property? There's 3 situations that are typical that these types of clients would want to do that. One is that if they don't want their property to pass to the individuals that are set forth in state statute. So this is often when you're estranged from, your children or something like that. Or if you want to change the amount of property that each of those individuals is going to receive. So if, one of your children has been living with you and taking care of you for a long time and you want them to get a higher percentage of your estate than the child that has ignored you for the past 30 years, you might need a will or a trust to accomplish that. Otherwise, if you leave the state statute, everyone's getting an equal share. Another situation is when one child needs, a larger share of the inheritance and the other one is very financially successful. So if you want to change the inheritance, or if you want to leave specific gifts, so you want your jewelry to go to a particular person, you want your gun collection to go to a different person, or you want, $5,000 to go to, your aunt, your favorite aunt, but everything else to be divided among your children, then you want to change what state statute says, and a will and trust can accomplish that. So there's also 5 common situations that incorporate those 3 principles we just discussed that we see a lot, where clients will say, well, distribution of assets is a big, important goal for me, and that's the main reason I want to put an estate plan together. So one of those reasons is that the client might be divorced with minor children. So if you've got minor children and you get a divorce and then you pass away, if you don't, state statute is going to say that everything's going to go to that child, right? But if everything goes to that child and they're a minor, then everything goes to their legal guardian for the care of that child. And we have an article at learn-about-law.com about what happens when minors inherit property in Illinois. So for more information about that, check out that article. But what's going to happen is that everything's going to go to your ex, who is the last person you usually want to have control of your assets, and then your ex is going to hopefully manage those assets for the benefit of your child. Well, most divorcees would prefer to create a trust and name someone that they trust to be the trustee, and as long as their child is a minor, those assets will be paid to the trust when they pass away, and the trustee, not their ex, is going to be responsible for distributing those assets for the benefit of the child. So the trustee will have the power of the purse, not the ex. So that's one situation where a trust can really help with distribution of assets. The second is if a client's estranged from a family member. I mean, this is pretty obvious. If state statute says that your child is you've got 5 children, and state statute says your estate's gonna pass in equal shares to each of the 5 children, but one of the 5 children you haven't spoken to in 40 years and is estranged from you, and you want to cut them out of the will, well, you're going to need to actually have a will or a trust to make sure that the people that you want to inherit actually do inherit. The third situation we see a lot is that a client wants to give some of their assets to a charity. So, my dad's very religious, and I'm sure that someday, if there's anything left in his estate for my brother and I to inherit, I'm sure a good portion of that is going to go to his local church. So, that's one thing you can accomplish with a will or a trust, is that if giving is something that's important to you, you can have a percentage of your estate plan go to a charity. Next is if you want someone outside of your family to inherit some or all of your assets. The typical situation we see here is people who are, maybe in their 50s or 60s or even 70s that aren't married but are life partners and have been living together for a long time. Maybe this is the second marriage for both of them, or the second major love of their life, and they're not getting married, but they want that person to get at least some of their assets. Often in this situation, they want that person to have a life estate in the family home, but have the vast majority of their assets passed to their children. If you want to take care of someone outside of your family, and also make sure that you set up a scenario where your family stands to inherit a good portion of your assets as well, that trust is a great way to do that, because you can set rules on what your partner can do with those assets during their lifetime, and make sure that if there's anything left over after your partner's lifetime, your children inherit what's left over of your assets. The last situation is, it kind of spills into this, what we were just talking about, but when a client wants to maintain some control over how the assets are used after they pass away. So a will can't really do this very much. A will just distributes the assets through a probate estate immediately upon the closure of a probate estate. And that's what will happen whether you have a will or no will at all if your estate just goes through probate. So state statute or a will act in the same way in this regard. But a trust will allow you to have, you call it the hand beyond the grave. You have control over how those assets are managed for a much longer term. And this is the situation we talked about, where you've got maybe young adult children, and you want your children to get a third of the assets when they reach 21, a third of the assets when they reach 25, and then the final third when they reach 30. Or we've had clients that have said, if my daughter graduates or goes to grad school, then she can get everything paid out early. If she doesn't, she's got to wait for a certain amount of time, or tie it to their grades. Or financial advisor clients of mine have had specifications about how they wanted the money invested until it was actually paid out to the beneficiaries. So that's something that a revocable living trust will do for you. It'll allow you to be as creative as you want with how your assets are handled after you pass away. And really what I tell clients is that anything you can dream up, they're your assets. Anything you can dream up about how you want them distributed, how you want them managed after you pass away, we can put into the language of a trust, and you really can have that control for the long term. So next week we'll talk about the next goal of a good estate plan, which is probate avoidance, and that's something that can be accomplished with trust. But give me a call if you have any questions about any of this. My phone number is 630-324-6666. We offer free consultations, and I do a lot of estate planning work. If you'd like to check out my other podcast, seizeyourbusiness.com is where you can go to check that out. It's for business owners. We interview business owners every week. And if you'd like to see more podcasts or video blogs, or we've got probably hundreds of articles on our website about legal topics, go to learn-about-law.com, and you can listen and watch and read to your heart's content. We have articles on just about every topic. Thanks so much for your time.